Hello, this is Joe Gailey, and I want to welcome you to another one of our educational webinars on the subject, Employees in Your Business. What is your obligation to the employees, and what kind of damages can the business suffer with disgruntled employees? Today's subject is going to be the Civil Rights Act of 1964, more specifically Title VII of that act. Title VII prohibits discrimination in employment based upon race, sex, religion, or national origin. Now, it's been around for about 50 years, and so we do have a pretty good body of case law about what this means, although it continues to develop yearly. There are basically two types of discrimination that the Act covers: intentional discrimination and what I call non-intentional discrimination. Okay. Intentional discrimination, I think everyone can imagine what that would be. That would be like hanging out a sign that says "Help Wanted, African Americans need not apply." Or maybe hanging out a sign that says American owned and American operated, all of our employees are Americans. That could indicate, and in fact would indicate, intentional discrimination. Today, there is a fair number of cases on intentional discrimination, but most of it borders on unequal pay, whereas minorities are paid less than others for the same work. The unintentional discrimination are things that the employer does that has what's known as a disparate impact on a minority. For instance, if you ask an applicant, a job applicant, have you ever been arrested? That has a disparate impact on minority populations because statistically, minority populations get arrested more than the other segments of the population. So the EEOC is taking the position that asking that question on a job application is unintentional discrimination. Another type of discrimination that we see now, unintentional discrimination, is asking on a job application, are you qualified to work in the United States? That is certainly a valid question after the person is hired. But before hiring, it may well create a disparate impact on the immigrant community and could well be illegal. Now, one of the provisions of the Civil Rights Act of 1964 is that it allows a jury to return punitive damages against an employer. Now, what is punitive damages? Well, those are damages meant not to compensate somebody, but to punish the employer for wrongdoing. And it can be any amount in the discretion of the jury. So it's always, any employer facing a Title VII suit has to be concerned about punitive damages. There are certain things that one can do to try to limit your exposure to that. For instance, being interactive. The employer needs to have a complaint system so that employees know how to file complaints, and it needs to be spread widely, and the employees, at least the managers, need to get training in the area. Failure to do that could show a callous concern on the part of the employer and could well result in the imposition of punitive damages. The employer needs to have policies and procedures prohibiting discrimination in the workplace, preferably in writing and in a handbook or a statement of non-discrimination. And they need to actively police it and actively monitor these things. Whenever a complaint for discrimination comes in, the employer has to investigate it and document the investigation. Failure to do so can be used as evidence of a callous indifference, which could justify the imposition of punitive damages. So later on, we're going to have a separate section on the role of the EEOC, the Equal Employment Opportunity Commission, and their role in these cases, because the employee has to file a charge with the EEOC before they can sue, and give the EEOC the right to sue on their behalf first. But we'll save that for a future installment. We thank you for tuning in to this installment, and we ask you to please tune in to the rest, and maybe you'll pick up some valuable information about how to protect your business and how to make your employees happier than they are now. Thank you.